So good morning to everyone, and I'm also very happy that we have this slot co-organized with ELSA, because I'm of the firm belief that the future of any legal system lies in the hand of young lawyers, and it was great to agree with ELSA on the topics that we want to cover in the 45 or so minutes that I'm going to speak. This is about the Charter of Fundamental Rights, and so we thought that three things might be of interest. So first of all, to give you a bit an idea of what this charter really is. And then I will also deal with the added value of the charter. Why should you consult this document? And then I will say something about the application. So if you agree with that, we start with the charter. What is it? It's called EU Charter of Fundamental Rights. That already gives you the idea that it's something fundamental. Some people were sort of laughing at the EU when it agreed on the charter, because they were saying, well, the EU is starting to mimic member states. As you know, member states talk of fundamental rights when they talk about their own constitutional system, and obviously the EU already, with the title, wanted to send a signal, well, watch out, the EU also is a constitutional system. It has its own Bill of Rights. Now, if you want to understand better what this Bill of Rights is, we have to go to Article 6 of the EU Treaty. And there you read in the first paragraph prominently, well, the Union recognizes the rights, freedoms, and principles as they are set out in the Charter. But obviously this article is far longer than one paragraph. And in fact, there is a trinity of EU fundamental rights sources. So in paragraph 1, we have the Charter, and the text of the treaty says the Charter has the same legal value as the EU treaties. And that's interesting because the Charter itself is not a treaty. So yes, it is EU primary law, but it is not treaty law. And the Charter is not the only source of EU fundamental rights. There is the obligation for the Union to accede to the ECHR, and the Union continues to be bound by general principles of Union's law. And that is an interesting point, that the entry into force of the Charter did not mean that the Charter is freezing the fundamental rights landscape of the EU. There is still this dynamic element for the court to continue building general principles of law. So a trinity of EU fundamental rights sources: the Charter, the ECHR, and the general principles of law. So the Charter from its very beginning has been a very special animal. It's an atypical piece of EU primary law. Already from its genesis, we could see that, because normally, as you know, EU primary law, EU treaties are negotiated in closed chambers by mostly elderly gentlemen during long nights, and they are agreed upon after these intergovernmental conferences. This was very different with the Charter, a very open process over a year, 16 meetings, even civil society input was guaranteed. And in fact, the members of that European Convention were mostly parliamentarians, not representatives of states. And then finally, the document was proclaimed in Nice, as we all know, in December 2000. But let us sort of underline here that the people who were sitting in this European Convention were coming from 4 different corners. So you had there the Commission, the member states, the European Parliament, and the national parliaments. And as I said, it was actually dominated by the parliamentarians. 4/5 of the members were parliaments. Plus, you had observers participating. So as I said, it was a very participatory process. I'm making that point because it gives the Charter a legitimacy that maybe other EU primary law has less. So I'm not arguing that the Charter is super constitutional law in the Union. Of course, you cannot check EU treaties against the Charter, but the Charter has indeed a special standing in the EU primary law. And if you want to interpret the Charter, if you as a young lawyer want to understand how to apply it, well, then you also have to be aware of another document, which is called the explanation relating to the Charter. And these were also drafted by this European Convention. And then I would also advise you to be at least aware of this book, which contains 5,000 pages of the travaux préparatoires of this process. If you want to interpret the Charter, that is a useful tool. And of course, you might also simply grab your mobile phone and have a look at the Charterpedia, which also provides you help in how to interpret the Charter. But now let's jump to the text. Now, what is it? Let's get a bit more concrete. The Charter is one single easy document. I always say the Charter is easy to read, but difficult to understand, and we will come to that. But it is easy in the sense that you just have to deal with one single text. This is not the case, for instance, with the ECHR, where you have many additional protocols, or just think of the European Social Charter, where member states have sort of a menu option to ratify different articles. The Charter is not like that. It's one single package. There's no flexibility involved. All member states are bound by all the Charter articles. These are distributed over 7 titles, 45 articles. It's a rather short document. The ECHR is close to double as long. So a handy document. The first title is about dignity. The second title is then about freedoms, rather classically fundamental rights, but already here you see some innovative approaches. There's a right on personal data. There's a right to conduct a business. So there is already here a bit of innovation. And then if you go to the title of equality, and I understand from the president of ELSA that equality and discrimination will be a major focus of ELSA. Equality is an interesting title because you see that it's far more specific than other equality-related norms in international human rights law. So you have actually specific groups being explicitly addressed. So for instance, the rights of the elderly in Article 25, the rights of persons with disabilities in Article 26, so rather specific provisions that you find in this title. Then the title Solidarity, which maybe was the title that was met with most interest, because it contains social, economic, and cultural rights in a legally binding document. This is very rare. Of course, also the UDHR, which just had its birthday, it also contains socio-economic rights, but this is a non-legally binding document. Here we have a legally binding document with the Charter that combines classical civil and political rights with social, cultural, and economic rights. Then we have a title on citizens' rights, and that is obviously rights that are attached to EU citizenship. So that's very typical for the EU system: a right to good administration, right to access to documents, the right to petition the parliament, freedom of movement, you name it. And finally, for the lawyers, of course, especially important, the title on justice, which maybe for the legal systems has been so far proved to be the most relevant title. And then the last title is about the general provisions, and that is about, well, how do I use all these rights that we have in the title 1 to 6? So for the non-lawyers, title 7 sounds boring, but for the lawyers, there's a lot of interesting stuff in there. So this was my brief summary of the Charter. Let's now dive into the question, what does it offer in terms of added value? I mean, is it worthwhile that you study this document? Well, and there I would say, you know, it's a bit, as you see, I'm a bit a Pink Floyd fan. There's sort of a dark side and a bright side of the Charter moon. You could see things from 2 perspectives, and I think we should be honest enough to mention both of them. Well, let's start with the bright side. Well, obviously the Charter is EU law, right? And as we know, EU law is stronger than international law. So for instance, the holy principles of union law, direct effect and supremacy are also relevant for the Charter. And you have the EU's own rights, citizens' rights that you have as a EU citizen enshrined there. And that makes it special and unique. In addition, the Charter as we at the FRA often call it, is a roadmap to human rights. So even if the Charter, legally speaking, would not apply in a specific case, it can bring in other human rights. It provides more visibility to human rights, and often it triggers a human rights dynamic at national level. So that has all been very positive, right? So let's move to the dark side. Well, the dark side of the Charter Moon is that the field of application of EU fundamental rights is limited, and that creates a potential for frustration. And it's also not easy to understand when the Charter actually kicks in. So the boundaries of Article 51 are foggy, and I will come back to that in more detail. And then we have to say that not all provisions in the Charter are rights. Some are only principles, and it is not that clear for a lawyer whether she or he is confronted with a right or a principle. And that already leads us to some first conclusions. So on the positive side, the Charter adds value to the landscape of fundamental rights via a new substantial strength and reach, and via a quite remarkable procedural speed. We will come to that. And finally, on the level of the judiciary and politics, it adds an element of creativity. Again, also here, there is a dark side of the moon, and that is that the Charter, being now in force since the 1st of December 2009, adds complexity to the overall human rights system, thereby maybe also in some corners a solid degree of confusion, and in any event, it adds a training need that was not there before. So let's now dig deeper a bit into the dark side of the Charter Moon, if you allow me. This is the famous Article 51 of the Charter, and it says that the EU is itself always bound by the Charter, but the member states only when they are implementing union law. And the wording continues along this rather defensive language, saying that the member states have also to be aware of the limits of the powers of the Union. The Charter does not extend the field of application of Union law, and it does not establish any new power or tasks for the EU. So clearly you see that when drafting the Charter, the mothers and the fathers of the Charter were a bit afraid that the Charter could be misused for a power grab by the European Union. And I think this is important to have in mind. But what does it then mean? I mean, what does it mean that the Charter only applies when member states are implementing union law? But basically, this is the same as member states acting within the scope of union law as we had in the case law before the Charter entered into legal force. So there must be, in order that the member state is bound by the Charter, there must be some minimal connection with union law. And obviously, what is not enough is to say, well, the case is relevant to that Charter article. So the Charter can never trigger itself for obvious reasons. That would be circular thinking. So next to the Charter, you need another element of EU law in order to trigger the Charter. And also the mere fact that the EU might be competent for a specific field is not enough to argue that the Charter would be applicable to that field, right? That is important to have in mind. So basically, we are talking about two situations where the Charter applies for member states. One is the so-called agency situation, and that is where a member state acts as an agent of the European Union. So the most primitive case is where a member state is transposing a new directive, applying that directive, and then obviously the member state is an agent of the Union and is bound by the Charter. Or, and that's the so-called derogation situation or authorization derogation, where a member state is invoking an exception, an authorization not to apply Union law. It has nevertheless to stick to EU fundamental rights, including the Charter. So if you derogate from obligations under the EU treaties, for instance, as a member state, you have to stick to the Charter nevertheless. So what is the problem with this scope? It's presented as a major drama, this scope thing. The problem is if you compare the Charter with the ECHR comes across as the far simpler document for a lawyer. because you never would pose yourself the question, well, does the ECHR apply in this context, yes or no? It always applies, semper et ubique, always and everywhere. When we talk about the charter, well, then you first have to check whether at all the charter is triggered. And the boundary conditions of this field of application are a bit foggy. Basically, you could say that the charter is in a way the shadow of any other piece of EU law that is applicable to your case. A well-known scholar said that just as an object defines the contours of its shadow, the scope of EU law determines that of the charter. So if you look at this man walking over this street, you see the shadow, and in the shadow you have the protection by the charter, but outside that shadow you would not be protected by the charter, and therefore the EU law, EU fundamental rights law protection is not fully encompassing. That's important to have in mind. The second dark moon perspective is the distinction between rights and principles. And there you have to look at Article 52, paragraph 5 of the Charter, which tells us, well, what is the difference between the two? And it clearly says those Charter provisions which are principles cannot be invoked before a court. They are not judicially cognizable, only vis-a-vis acts that are implementing these principles. But without such implementing acts, these principles cannot be directly invoked. They don't grant you a direct entitlement as an individual. Now, why did the mothers and the fathers of the Charter introduce this distinction? Well, that was a political deal because one did indeed agree that also socioeconomic rights should be part of the Charter, but the cost of that compromise was to say, well, let's integrate these rights, but at the same time, let's also say that not every provision in the Charter is a right. Some are only principles. So, and the distinction is clear. What is less clear is, well, which of the Charter provisions is a right and which is a principle. And the explanations which are meant to explain to us everything are not explaining much, because they simply give examples of principles. So for instance, we know that the provision on the rights of elderly people is not a right, but a principle, or the provision on environmental protection is not a right, but a principle. At the same time, however, the explanations say, well, some provisions are both. They have elements of rights and they have elements of principles. So we are left with a vague hope that the Court of Justice will tell us what are the rights and what are the principles. You will have to look into different factors, of course. I mean, the language, is it rather language of an individual entitlement or a political aim? Is the Charter made dependent on national or EU legislation? Is there a large margin of appreciation? If all that is the case, it's rather a principle and not a right. So all that talk about the dark side of the moon leads to a situation where we see that the Charter is perceived at EU level very differently from the national level. So again, a prominent lawyer who happens to be also the president of the Court of Justice had said that the Charter is one of the most important achievements in the whole history of European integration. And most probably he was mainly having in mind the case law of the Court of Justice, the impact of the Charter on EU policymaking and on EU legislation, where indeed the Charter provoked a change, a culture shift. No? Extremely impressive. We have then another academic who speaks about the Charter's use at national level and qualifies it as meager, underwhelming, sporadic, rare, and even disappointing. That is a bit confirmed by FRA data, and you see this little pie chart there, which tells us that only 7% of the lawyers often use the Charter, 26% sometimes, and actually close to 40% of the lawyers never used the Charter. So there must be some explanation for that. And if we talk to legal practitioners, this is what we get. That's an expert from Spain, and he said, well, there is a confluence of three persistent factors. Firstly, the Charter is ambiguous, and that brings us back to Article 51 and Article 52, paragraph 5, so the scope of application and the distinction between rights and principles. Secondly, there's a lack of awareness. We don't have training. We don't know about the Charter. And thirdly, the governments, the training academies, they don't invest enough to promote the Charter. If we then talk to rights holders on the street, people on the street, our mothers, our grandmothers, our fathers, well, the situation is quite clear. People are aware of the ECHR, but they are much less aware of the Charter of Fundamental Rights. Of course, those states that have not such a long experience with the ECHR, because they have newer constitutions, states in the center of Europe or Eastern Europe, there the discrepancy between the awareness is far lower. But for states that have a long tradition with the ECHR is still far more prominent. So the problem is, of course, not that the ECHR is prominent, but that the Charter is less prominent. So what, to already come to a conclusion, what is our feeling now after we have heard all that? It is a bit dull, right? So I think every scholar and every young lawyer who deals with the Charter, gets to know the Charter, comes to this moment of a Tur-Tur effect. I call it Tur-Tur effect because maybe when you were a child, definitely I read it, you read the book Jim Button and Luke the Engine Driver. And they were passing the desert and then they see an illusionary giant, a huge figure, and they were super impressed by that giant. And the closer they came, the more the giant was shrinking. It was an illusionary giant. And that's a bit what you have with the Charter, right? The more you know about it, the more you read to the end of the text and you come to Article 51, etc., the more you are slightly disappointed and you say, well, this is not that impressive, right? It's actually a disappointment. But wait with your Charter depression. I think it's too early. There is hope. There is a bright side of the Charter moon. So think of the breadth of the catalogue. Think of its EU law nature and think about its inspiring potential. And now we start to jump on the bright side of the moon. So now it's going to be happy news. So in case someone fell asleep already now, you can wake up again. Let's turn to the bright side. If you compare the Charter with other international human rights catalogues, but also with national human rights catalogues, you will see that the Charter is impressive in its encompassing and modern wording. So if that is too vague for you, let's run a quick test and compare the Charter with the ECHR. So these are all those provisions in the Charter that are also mirrored in the ECHR. Well, that's not much. Huh? Just think that beforehand you saw the same graph with 54 articles. And this small group are those provisions in the Charter that you also find in the ECHR. These yellow provisions of the Charter you would not find in the text of the ECHR. So of course, admittedly, I'm not here arguing that the ECHR would not at all protect these rights. I'm just saying that the citizen would not find these rights in the text of the ECHR. Then you have a group in Title 5 of rights which by definition cannot be part of the ECHR because they are reserved to union citizens. And that already adds value of the Charter. And finally, you have provisions in the Charter of Fundamental Rights where, yes, you have a pendant, you have a mirroring provision in the ECHR, but where the protection of the Charter goes further. So just think, for instance, about the right to marry and found a family. In the ECHR, this is a traditional combination of a man and a woman. In the Charter, this is gender neutral. Or the ne bis in idem in Article 50. That is in the ECHR, just covering the territory of a member state. In the Charter, it covers all member states. Or the right to an effective remedy and a fair trial. In the ECHR, of course, you have Article 6, but it only covers civil and criminal procedures. The Charter covers any potential public law procedure you could just imagine, including asylum. That's very important. It made a huge difference. So let's do the same with national human rights catalogues. Let's run a little test. And here you see a graph that shows you those provisions, or it shows the bars related to the charter provisions. And the longer the bar is, the more member states you have whose written human rights catalog does not reflect the respective charter right. And I think that's quite interesting because it's rather counterintuitive. You would have expected maybe that some titles indeed are not at all reflected in national constitutions, for instance, socioeconomic rights. But you would not expect that actually across the board, you have many member states' constitutions that do not recognize in their text fundamental rights laid down in the Charter. So oversimplifying maybe a bit, one could say that on average, for every provision of the Charter, you would find 10 member states whose written constitution in its second or first part, so that the fundamental rights catalog, does not reflect that respective charter right. And that has an enormous potential for the Charter to become what we call a roadmap to fundamental rights, because it can inspire the national human rights community. So that was all about the substance. Let's now jump to the procedures. Does the Charter offer a procedural advantage compared to other human rights catalogs? Well, I think it does. First of all, what is important is that we have to distinguish between the EU itself and its member states. So obviously, the EU itself cannot be brought before the Strasbourg court, as you see from the graph, as long as the Union has not acceded to the ECHR. What is also important to know is that there is no Article 51 test for the EU itself, because the Charter always applies. In fact, the EU institutions are even bound by the Charter if the EU is moving outside its own framework and competences. For the member states, as we learned, this is very different. So where is now the added value compared to, for instance, the ECHR or other fundamental rights? Well, it stands exactly within this green circle here. In the moment where you come to a positive end of the Article 51 test, so you say, yes, the Charter applies, then you have additional legal avenues that open up. For instance, you could ask that the European Commission launches an infringement proceeding, or maybe more realistic, more frequent, you could convince your judge that she or he brings your case before the Luxembourg court. And that is, practically speaking, very interesting and relevant, because the procedure vis-à-vis Luxembourg is, of course, far, far quicker than a procedure in Strasbourg, where, by the way, you would have first to run through the whole national legal system. You have to exhaust all local remedies, and this you do not have under the EU-track procedure. You don't have to run through all the local instances. So I think that is important. And yesterday we had a closed a small working group, and there was a very experienced lawyer saying, well, if I can advise young lawyers sort of to strategize well, I would say use the Luxembourg system more. It is so efficient and it's so quick for a legal practitioner. This is important. And now let's move to another aspect of an added value of the Charter, and that is the direct effect of EU law. The Charter, being EU law, also profits from this direct effect. And as you all know, EU primary law, EU secondary law, and national law stand in a normative pyramid, meaning that EU secondary law has to be in line with the Charter. If it is not, it can be declared null and void by the Court of Justice. For a long period, this did never happen, but the Charter also here brought a change. Since the Charter entered into force, the Court of Justice became far more aggressive vis-à-vis its own legislator, telling the EU legislator, well, watch out, if you don't do your homework, I will strike down our own legislation. And this happened in the area of data protection, agricultural law, and so on. And also vis-à-vis national law, you have this indirect effect of the Charter, that national law has to be interpreted in a manner that is coherent with the Charter, or even if you have a direct effect, national law that is in contrast with the Charter has to be set aside. So on this vertical dimension, this is a very important element. However, the Court of Justice went further. There's not only a vertical direct effect, there's also a direct effect between individuals. So for a long time, one would have said this is not possible because the Charter is addressing states. It's not, and primary law is also directed vis-a-vis to states and not to individuals. But the court said this wording does not preclude the application of the Charter to relations between individuals. If a provision is mandatory in nature and sufficient in itself, and does need any further provision to be more specific to grant a right to an individual, then it might have direct effect between private parties. So far, the court has recognized this for 3 provisions. Again, important, Article 21, prohibition to discriminate, Article 47, the right to an effective remedy and fair trial, and the right to annual period of paid leave. Whether the court will go on and develop this direct horizontal effect also for other Charter provisions is left open. I don't think that will become a major trend, but there might be definitely follow-up. So I'm now coming to the last part. How is the Charter used? I think for using the Charter as a lawyer, it's important that you're very well aware of Article 52. So we already had 51, which was on the field of application. 52 is on the scope and the interpretation of the Charter. And its paragraph number 1 is important to understand under which degree a limitation of a Charter right can be justified. And there are 3 elements which are key. But first of all, any limitation has to be based on law. Secondly, the limitation has to respect the essence of those rights. If the essence is affected, then you cannot justify the limitation. And every limitation has to conform with the principle of proportionality. No? There must be a recognized general interest, and the limitation must be necessary to meet that interest, or it has to be necessary to protect the rights and freedoms of others. The second paragraph is also important because some of the Charter rights you would not only have in the Charter, but also in the treaties. So in that case, you would have to read the treaties well, because the Charter right has to be interpreted under the conditions and the limits defined by those treaty provisions. And finally, the Charter and the ECHR are like 2 sisters. They are in a relationship of a symbiotic relationship, and where you have a Charter provision that is reflected in a ECHR provision, then the Charter provision has to be interpreted in the same meaning and the scope as the related sister provision in the ECHR. So even without accession, there is a very strong twinning between the EU system and the ECHR system. And finally, when it comes to the level of protection, the Charter cannot interpret it as limiting rights. And I will come back to that element. It will be important to sort of, when using the Charter, also look into other international human rights agreements to see whether one applies the Charter correctly. Let's make maybe a little test. So you have a provision, you're working on a concrete case in your law firm tomorrow, and you see that there is a limitation of a Charter right involved. But the first question that you have to ask yourself, is it an absolute right or not? The problem with judging whether a right is an absolute right or not under the Charter is that the Charter is silent on this. So that's very different from the ECHR, where for each and every provision of the ECHR, you also have a definition when it can be limited, what sort of public goods you can invoke. And also you have a provision on what rights are derogable and which are not, Article 15 of the ECHR. You don't have that in the Charter, and therefore you have to go back to the ECHR to understand what is an absolute right or not. If you conclude it's not an absolute right, then you have to pose the second question: does the limitation affect the essence of the right? If it does, then you can never justify the limitation. That is what happened to the Data Retention Directive. You might remember where the Court of Justice said this has to be struck down. If it does not affect the essence of the right, well, then you have to go to the proportionality test as it is outlined in Article 52. How does that look? Well, 5 questions you have to pose yourself in your legal practice tomorrow when you are working on a concrete case. Do the limitations serve a legitimate objective? Are they appropriate to address the problem identified? Are they necessary to achieve the legitimate objective? Or is there an alternative route that would interfere less in fundamental rights? And that's proportionality in the stricter sense, are the limitations proportionate to the aim used? So if you reply to one of those 5 questions with a no, well, then you cannot not justify the limitation. If there is a yes to all of those, you still have to look at the ECHR and check whether there is a sister provision in the ECHR. If there is a sister provision, well, then you have to see whether the limitation is in line with the ECHR. Is it consistent with the ECHR system? If not, you cannot justify the violation under the Charter. If there is no sister provision in the ECHR, well, then you still should look whether there is a sister provision in another international document, and then see whether under that document the limitation is justifiable, because you remember there was this Article 53 saying that the Charter cannot become an argument to limit other obligations the EU member states have entered into, and the EU itself. Okay, let's say now something about the de facto use of the Charter. There is an asymmetry involved. There are certain Charter articles that are used very often at national level, and that is definitely the right to fair trials and remedies, Article 47, the super performer, but also the equality provisions, Article 20, 21, very often used. The right to good administration, that's interesting because it actually does not refer to member states, is still used often at national level. Other rights are used far less, and there is also the fact that in some policy areas, the Charter rights are used very often, and in others much less. Just to give you 3 prominent policy areas where the Charter is used often: data protection, cooperation in criminal law, and asylum and immigration are 3 examples where this is often the case. Let me give you some concrete cases to make it a bit more concrete what courts have been saying about the Charter, and I'm soon coming to the end. Well, here you have the Constitutional Court of Slovakia, who says that the Constitution has to be interpreted and applied within the meaning and the spirit of the Charter. So the Charter has become for constitutional courts an important frame of reference. So yesterday we have heard that only few constitutional courts use, formally speaking, the Charter as a yardstick for constitutional review. That's of course very true. But for many other constitutional courts, nevertheless, the Charter plays an important frame of reference. You have here the Czech Constitutional Court, which says that the legal principle of ne bis in idem under national law only applies to 2 procedures that take place in the territory of the Czech Republic. However, that Article 50 of the Charter expands this principle to the whole territory of the European Union. And that, of course, adds value to the legal system in the Czech Republic. You have here the Supreme Administrative Court of Lithuania, where the court says that the Charter established a right to good administration and that institutions must handle requests impartially, fairly, and within a reasonable time. As I said already, that's interesting because Article 41 is actually only directed at the EU institutions. Nevertheless, courts in many member states, Italy, Bulgaria, etc., say, well, we take Article 51 as an inspiration and as an expression of a general principle of law, and therefore it is relevant in our legal system. Finally, the United Kingdom judgment in the Benka-Bush case. That is, of course, a well-known case because it is so instructive and it shows so well where the added value of the EU is. And you might all remember that under the Human Rights Act in the UK, judges can identify a conflict between national legislation and the ECHR, but they cannot disapply for that reason the conflicting national norm. And in the Banker-Bush case, the question was exactly that. Well, what do we do if the conflict arises not with the ECHR, but with the Charter? And there the court said, well, then it's a different cup of tea, because then you indeed have to disapply the national contrasting norm. And finally, a quote from the Slovakian court. This was about data protection, where the court said, well, consumer protection, where the court said, well, consumer protection is in our legal system not a constitutional value, it's not a fundamental right. However, Article 38 is interesting, and we are now reading our own national legal system in the light of Article 38, and therefore give the consumer protection a push. So let me now come to my really last two slides. And that's a bit summarizing of what we find in terms of the application of the Charter at national level. But what we see is that the national courts do not so often refer to the Charter. If they do refer to the Charter, it's rather superficial. And there is an Article 51 silence, meaning that courts would not so much explicitly engage with the question whether at all the Charter applies. Rather, they engage in a twinning exercise, namely applying the Charter next to the ECHR, and therefore not really explaining what was now the effect of the Charter, what was the effect of the ECHR. But there is a trend that is definitely positive, both in terms of the quantity of cases where the Charter is used, but especially in terms of the quality of the Charter. And we have heard that yesterday with the example from constitutional courts using the Charter as a yardstick. There are few references by the legislator. The Charter is obviously not used a lot in impact assessment of legislative drafts, which is to be explained by the fact that the procedures for these impact assessments normally only refer to the ECHR, but not the Charter. Most references are rather superficial. And then you have the governments, where so far there was not much sort of policies in order to promote the Charter, despite the fact that Article 51 actually asks member states to proactively promote the Charter. But also that is changing. There are now Charter focal points, very freshly established, and we have to see where that leads us. But there are many points for a change, pointers for a change. We have so far this old picture that the judiciary is running the show, the legislator is not using the Charter much, and the governments so far are not really exposing themselves. But this is changing. We are witnessing a change that will lead to a far more balanced picture. And in order to guarantee that all corners of governance are involved in the Charter application, we need an exchange. And this is exactly what we are doing today. We are exchanging experiences across the three pillars of governance. And I think I will conclude here, maybe just saying that I think for a young lawyer, the Charter is exciting. There is, of course, still a lot of insecurity involved, but to conclude with a quote by Jeremy Bentham, the power of the lawyer is in the uncertainty of the law. And I think that is for young lawyers maybe especially inspiring. Thank you very much.